Okay, doesn't that dispute create enough of a factual dispute that the trial court should not have granted summary judgment at this point?
I'm a little bit lost by the question, Your Honor, and maybe you can help me. When you say the dispute, what are you referring to?
About what a claim is, and what claims are covered and excluded, and what claims the Acosta suffered a loss on. Doesn't that all create sufficient factual dispute to have precluded summary judgment at this point?
No. The reason for that is the interpretation of an insurance policy is an issue of law. Coverage is determined, in cases say Florida has a bright line rule. It's determined from the allegations of the complaint. The definition of what a claim is, I suggest to you, is in the policy. A claim is defined in two different ways. It's a written demand, or, as it happened in this case, a request for a tolling of the statute of limitations, or a legal proceeding. That is what a claim is, a legal proceeding. The contention that each count of the legal proceeding is a claim violates the terms of the policy. The policy goes on to say that a claim can allege related wrongful acts, even though there are different parties, even though they've got different legal names, as long as there's a common nucleus of facts. And yes, sir. And I got one more answer to you.
Acosta, in support of this claim-to-claim analysis, they are alleged, right, in this case, rely on the case of AT&T versus Faraday.
Yes, sir.
Didn't the Faraday court reject the same interpretation of claim that you are advancing here, based on a similar policy definition?
It definitely rejected the position I'm advancing. Yes. I don't believe the policies are the same, and it's the law of Delaware that was applied here. There is a Florida case that was decided by the 11th Circuit called Wendt, which is what the judge relied on, which says as long as there's a common nucleus of facts, the prior litigation applies. But I want to go back to the question you really both asked.
I will give you 20 seconds to do that.
I'll do it in 20 seconds. This claim argument is a red herring, because if you read the underlying case, what you see is that every count alleges the allegations of every other count. And the claims that are against Acosta repeat the same allegations over and over and over again. So even if we were going to do a claim-by-claim analysis...
You didn't make it. Thank you.
Thank you.
Thank you. I'd like to try and address some of the questions that were asked of the appellees that we think we have better answers. That being said, I'd like to start off by talking about AT&T versus Faraday. AT&T versus Faraday did not involve similar policy language. It involved identical policy language. If the court goes back and looks at that AT&T case, you're going to see it's a national union policy. It's one of the two policies being talked about. And that appellate court quotes the identical language that we're dealing with in this national union policy in this case. Further, the Wendt decision out of the 11th Circuit doesn't address this issue at all. In Wendt, what you had was two lawsuits, both of which were dealing with the sale of bad securities. Lawsuit number one was a class action. Lawsuit number two was some individual who sues for the sale of that same bad security with no explanation as to why. So presumptively, he's somebody who must have opted out of the class. It's the identical conduct. The only differential that the insured was arguing in that case was my security has a different certificate number. The 11th Circuit said that's not enough. You have to look at the wrongful acts. Further, one of you, I believe it was Judge Wolf, asked, would this turnover suit have been covered had it been tendered as a claim? to some carrier in June of 2001? The answer is clearly no. Because the only issue was the possession of property. Moreover, despite the excerpts out of the turnover suit that we read, here's paragraph 17 of the turnover suit. The files, equipment, mail, and other personal property of marketing specialists of the estate is property of marketing specialists.
Whether it was covered or not, if in fact we find that the turnover suit did allege wrongful acts, and that there are facts, underlying facts that are basically the same, would you?
I think I have to break down my answer if I can, and then let me know if I'm not being responsible. I'm genuinely trying to be. It is in fact beyond dispute that some of the allegations of that turnover suit get repeated in the underlying litigation. We don't deny that. For instance, there's a conversion count in that underlying litigation, and that conversion count, if we had paid a loss in connection with that conversion count, and that's what the evidence showed, we'd probably be out. I get that. But so that conversion count would be what appellees are now trying to suggest matches up to the count for damages that is somehow connected with the count for give us the property back. But like so many times in complex commercial litigation, I think this gets right to the heart of Judge Marstow's question. You have here a 200-page complaint. The kitchen sink is in this complaint. And as the discovery goes on, and as the parties are litigating it, some of these things fall by the wayside because somebody just sat down and wrote them one day, and that's not what the litigation became about. And that gets to the heart of your question.
Yeah, and I'm not a big fan of claim committee policies. But isn't that what a claim committee policies are all about? I mean, you're on notice, and you get filed before, that you're alleged of wrongful acts. Even if the claims fall out, even if it's alleged in previous lawsuits, you're on notice. And
I acknowledge we were on notice that we were being accused of being in wrongful possession of property, this tangible personal property of the state. But I cannot stress enough what we actually got sued for and what we settled. The claim that we settled, and the record evidence shows that we settled, had nothing at all to do with possession of property. It wasn't even, as Your Honor was asking me on the first go-round, this sort of tortious interference claim.
okay, well, help me again.
Okay.
If I understand what you're saying just now, that if we file off that we can't look, and I know you're not saying this, but if we file off that we can't look beyond the allegations of the individual complaints in each case, you're in trouble.
No, sir. We have shown, Your Honor, in our initial brief where you can find, and as well as in our reply brief there, where we've shown you where you can find the allegations that ultimately did become the loss in this case, where you can find those allegations in the second amended complaint that have nothing at all to do with any notion that we wrongfully possess property, that have to do with, in fact, this claim that we destroyed the goodwill.
I read the brief. Now I'm getting a little confused here, but what I heard you just say before was, because of the conversion count, if that conversion count had stood, you would not be able to proceed against the insurance.
No, Your Honor, if that's what you heard, I misspoke. I apologize then, I misspoke. We don't have any potential right to recovery on any loss in connection with that claim, the conversion count. But that wasn't what the loss was here. In this particular case, the loss was we hired these employees, we serviced these manufacturers, and somehow we destroyed the goodwill. That's why you heard the suggestion that there was this notion of $11 million of